I don't do any follow-up investigation on cases like this. I'm not an investigator. I'm just an officer.
So your testimony is basically the reason it took over 4 hours to just make a decision on whether to arrest my client for the charge is because of SAPD's work schedule, essentially.
It sounds about right. Yeah.
That's not really fair, right?
It sure is. The only things I requested was a detective that handled the case. And then once I was directed to do so, a CSI tech to take custody of the evidence. Like they would take custody of a firearm case or anything like that. They're going to photograph it, take custody of it. Those are the best of my memory. Those are the only two things I remember asking for.
So he came and took fingerprints of the check.
I remember him documenting the check, and I remember him taking custody of it.
Well, that was the reason he was mad at you for not wearing gloves, because you were painting the check.
Right, yeah.
So you guys can get a person out there to do fingerprint analysis, but you can't get a person out there to look at the signature, determine the sign.
To do signature analysis?
Right.
I don't know all the capabilities of our investigators or CSIs when it comes to checks.
Officer, at one point over the course of the 4 hours, you told a fellow officer that you thought maybe this would be an at-large case?
Yes.
What is an at-large case?
An at-large case would be if we have some form of an offense, but maybe not enough evidence to make an arrest. And so we would leave room for a follow-up unit to do more investigation to determine if they're going to file a warrant for the arrest of the individual. But the report would still be written as though the person is the suspect, and then allow units to do a follow-up investigation.
And sometimes you don't arrest people at the scene. You do an at-large case, right?
Right, yes.
And so in that situation, you maybe wouldn't have arrested Carlos, and you would have done more investigation and then determined if there was enough evidence to proceed on the case.
You're asking in the case of an at-large?
Right.
If we didn't have, let's say, one of the pieces I had on that day, then I would have been very happy to release him and just file it at large and let investigators follow up with the case.
So I've asked you about several things that you didn't have. Wouldn't this case would have made more sense to be an at-large case so you could have further investigated it?
I don't do any follow-up investigation on cases like this. I'm not an investigator. I'm just an officer.
So your testimony is basically the reason it took over 4 hours to just make a decision on whether to arrest my client for the charge is because of SAPD's work schedule, essentially.
It sounds about right, yeah.
That's not really fair, right?
It sure isn't.
Officer McFadden just admitted under oath that Carlos Pettis sat handcuffed in the back of a patrol car for more than 4 hours because of San Antonio PD's staffing gap between shifts, not because investigators needed the time to build a case. Asked directly whether that was fair, he said it wasn't. That admission matters more than it sounds. Under the Supreme Court's 1968 decision in Terry v. Ohio, police can briefly detain someone on reasonable suspicion, but that detention has to stay short and investigative. It cannot become a stand-in for an arrest. Courts have allowed some extra time when officers are diligently pursuing a way to confirm or dispel their suspicion quickly, a standard the Supreme Court laid out in 1985's United States v. Sharp, but diligence is the whole exception, and McFadden testified there wasn't any, just a wait for the next shift to start. The Supreme Court addressed exactly this gap in 1983's Florida v. Royer, holding that officers must pursue the least intrusive means reasonably available to confirm or dispel suspicion as quickly as possible. Waiting on a schedule is not that. Under these circumstances, a 4-hour hold justified by administrative convenience rather than active investigation stops looking like a Terry stop and starts looking like an arrest the state never had probable cause to make.
How are you currently employed?
I work for the San Antonio Police Department.
How long have you been employed with San Antonio Police Department?
2 years.
What have been your duties over the past 2 years?
Patrol. I work patrol on the south side.
What general duties are involved when you are on patrol?
We respond to calls for service that come into 911, which could be anything from a noise complaint up to a shooting.
And you stated you're assigned to the south side. Was that correct?
Yes, ma'am.
What shift are you currently working?
B shift.
What are the hours of B shift?
1:30 in the afternoon till 9:30 at night.
Are you a certified peace officer?
Yes.
What education is required to become a certified peace officer?
You have to go to a police academy and pass a T-Cole test.
What was your position on March 7th, 2025?
I was on patrol.
Were you on duty on March 7th, 2025?
Yes.
Are you familiar with the case under SAPD 25045709?
Yes.
What case is that?
That is case we're here for, or a fraud case.
Okay, and on March 7th, 2025, were you dispatched to a location regarding this case number?
Yes.
Do you recall what location you were dispatched to?
The Wells Fargo Bank on South Zarzamora.
Is that in Bexar County?
Yes.
Were you the only officer assigned to the call?
No. Officer Chavez was my cover officer.
Prior to arriving to the scene, do you receive information about a call?
Yes.
How do you receive that information?
We receive it through our city laptop, which is mounted in our vehicle. And whatever information is given to the 911 call taker gets put in text form on our computer screen.
Is that information transcribed real time?
Yes. As soon as it's put onto our call screen, it shows it's stamped with a timestamp.
Okay. So when you arrive to a scene, do you generally have an idea of an individual you may be looking for or need to take attention toward?
Most of the time when we're arriving on scene, we have some concept of the nature of the call. Sometimes we have person description, sometimes we don't.
So based on your training and experience generally, do you find that the information you receive is consistent with what you observe when you arrive?
It varies.
In what way?
Oftentimes, clothing description is wrong. Someone might say they have a red shirt, blue pants, and we get there in reality they have just the blue pants, and so something else is off. So oftentimes we will either consensually encounter somebody or detain somebody based off of one article of clothing matching the description given on the call screen.
So in this case, did you have a clothing description that you were looking for?
Yes.
What clothing description were you looking for in this case?
They said the suspect was wearing a reflective vest.
Okay, a reflective vest. Was there any other descriptors given?
I believe it said he was wearing a blue shirt.
Okay. So when you arrived to the scene on March 7th, 2025, what did you visually observe?
When my partner and I both got there, I observed a Hispanic male, which was the description given, wearing a reflective vest, moving towards a vehicle ready to leave. And then my partner was entering into the bank.
Okay, I'm going to stop you there. We're going to break it down. So you observed an individual getting into a vehicle. Do you recall what kind of vehicle?
I don't.
You don't? Okay. Do you recall what you did when you observed that?
Yes, I made contact with the individual and then detained him with handcuffs.
Okay, why did you detain him with handcuffs?
Because based off of the call that came in, we had reason to believe a crime was being committed. And the specific detail that was most recent was that the individual was getting agitated or aggravated and was trying to leave.
Gotta be sustained.
Okay, so you detained this individual in cuffs, correct?
Yes.
Did you develop your investigation more as you were at the scene longer?
Yes.
Did you only detain one person on March 7th, 2025?
I detained one person and my partner detained another person.
So the person you detained, did that end up being the suspect in the fraudulent use or possession ID info case?
No.
So who was the person you detained?
Mr. Perez.
The first person you detained?
That I detained. I'm sorry, I misunderstood.
Yeah, not Officer Farley.
The person that I detained, I don't remember his name, but he was not the suspect.
Okay, and how did you determine he was not the suspect?
The caller, the bank teller that called into 911 indicated to my partner.
Hearsay? Confrontation.
So
Sustained with regards to hearsay.
once you detained the suspect, what did you do?
Once I detained the actual suspect.
No, once you detained the person you said you detained at the scene, what did you do?
That person only spoke Spanish, and I only speak English. So someone that was standing around spoke English and Spanish and translated between the two of us. Once my partner indicated that the guy I had was not the suspect, I released him from custody and explained through Spanish translation why we were there, how he matched the clothing description, and that he was free to leave.
So did you take him out of cuffs?
Yes.
Did you ever apologize to him?
I believe so.
Yeah. Okay. Are you admitting then to this jury that you made a mistake?
Sure. Yeah.
Yeah. Have you made mistakes before?
Oh, yeah.
Okay.
I'm very human.
What the jury just watched was Officer McFadden explain, in his own words, how he decided who to detain. A reflective vest and a general area, nothing that actually pointed to one specific person. He was right about the vest. He was wrong about the man, and he knew it fast enough to apologize and take the cuffs back off. Texas's own standard for this kind of stop comes from the Court of Criminal Appeals' 2010 decision in Crane v. State, which looks at the totality of the circumstances and requires specific articulable facts connecting a particular person to a particular crime, not a trait shared by whoever else happens to be standing nearby. A reflective vest on a job site is not a fingerprint. That distinction, specific facts about a person, not a description anyone nearby could match, is exactly what separates a lawful stop from a coin flip. The Fourth Amendment protects Carlos Pettis exactly the same way it protects the man McFadden cuffed by mistake. And by McFadden's own testimony, neither man got more than a matching vest and bad luck.
So arresting the wrong person, that was embarrassing.
Not at all. He wasn't arrested. He was detained.
You're human and you made a mistake at your job.
Sure.
You have a very important job, correct?
Yeah, I would say so.
When you make a mistake at your job, someone loses their living for some period.
If I were to arrest the wrong person, then that would be a very big mistake. In this case, someone was just detained with handcuffs.
How long between the arrest of the unknown person, how much time passed between the time that you arrested this unnamed person and Carlos? How much time?
Very short time from putting the first person in handcuffs, detaining him with cuffs,
Yes.
to the time that I released him, or to the time
that you were detained. How much time?
very short period of time. I believe I was detaining the unknown male at the same time or in the same close time period as Alex was detaining Mr. Pettis.
And you said both individuals were in yellow work vests.
Both individuals were in reflective vests.
So Carlos was dressed as his from the job site.
Yes, both individuals were dressed that way. Yes.
So whenever you had the unnamed person detained, Carlos would have had the opportunity to escape, to leave.
I'm sorry, Carlos. Could you just clarify who we're talking about here?
Yeah, this is Carlos.
Good deal. I just want to make sure.
Got it.
Yeah, Mr. Pettis. Got it. So the only reason is I've just been referring to him as Mr. Pettis. So Carlos Pettis. So he would have had an opportunity to escape. Yes.
But he didn't do that.
No.
He actually just stood there and watched all this happen. Right.
To the best of my memory, at the time that I was detaining the first person, Mr. Pettis was being escorted out of the building and was detained at that moment. Even though handcuffs weren't placed on him yet, he was detained at the moment that he was interacting with police.
When you initially approached Carlos, you approached him pretty aggressively, right?
I don't know that I was aggressive. I approached Mr. Perez in the way that I approach a lot of people. And at that point, I'm just investigating a possible crime.
Investigating a possible crime.
Yes, sir.
The first thing you did when you made contact with him was put him in the handcuffs, correct?
Yes. Yeah. The first thing that we did was place him in handcuffs. Yes.
So you didn't ask him one thing about the event or any fact.
I don't recall if I asked him anything before placing him in handcuffs. No. And the same.
Thank you if you didn't.
No, not at all. No. Most of the time we put handcuffs on prior to having conversation with possible criminals.
But you didn't really have any information that he did anything wrong with that.
Yes, I did. I had and called the 911 indicating that someone matching his description was trying to pass a fraudulent check and that they were trying to leave the location.
But he actually wasn't trying to leave, was he?
At the time that I was interacting with him, no, he wasn't. I was going based off of credible info from the person calling 911.
And but the person that was trying to leave the location was never actually Carlos. It was the other guy, right?
I don't know whether or not Mr. Perez was trying to leave the location. I was running based off of what the caller was telling the 911 operator.
Before you put Mr. Perez Carlos in handcuffs, did you ask to see the surveillance video in the bank?
No, not at all.
Did you ask to see any bank records?
No.
So you just completely relied on what you learned from the bank.
Again, placing someone in handcuffs is not an arrest. They're just detained, and that's for our safety and for their safety.
For your safety and his safety, but he was very compliant, right?
Yes, after we put him in handcuffs, he was very compliant.
He was compliant before you put him in handcuffs.
It appears he was compliant walking out the door to the vehicle, and then he was compliant while we put him in handcuffs. Throughout the entire call, I knew Mr. Perez to be nothing but compliant.
So he was very friendly and polite the whole time.
Yes, good guy.
And he seemed
confused as to what we were doing there and why he was in handcuffs.
By his own account, Officer McFadden's first move with Carlos Pettis wasn't a question. It was handcuffs. He testified he doesn't remember asking Pettis anything before restraining him, and that this is standard practice for his department. He also testified he never asked to see the bank's surveillance video and never asked for its records, not that day, and not at any point across 4 hours. That combination is legally significant. The Supreme Court's 1979 decision in Dunaway v. New York held that when a detention takes on the hallmarks of a formal arrest, immediate physical restraint, extended custody, no meaningful effort to quickly confirm or dispel the suspicion, the Fourth Amendment requires actual probable cause, not the lower reasonable suspicion standard that justifies a brief investigative stop. Handcuffs first, unverified secondhand information for hours after. Under Dunaway, that isn't an investigative detention anymore. It's an arrest. And the record McFadden gave this jury doesn't show probable cause supporting one at the moment those cuffs went on. Every hour that passed without a single independent check, no video, no records, no corroboration beyond one phone call, is an hour the state has to explain, not the defense.
It's more about if we're having effective communication.
When you had that conversation with him, did you learn about a Luis or Alberto Vasquez?
I don't recall.
Do those names sound familiar to you at all?
Say the name one more time.
Luis Vasquez or Alberto Vasquez?
I don't recall.
So you never heard about gardeners in Mr. Butler's house that had access to the inside of the house and he wrote checks to?
That sounds something like that sounds familiar. Something about gardeners. I don't recall exactly what we talked about on the phone.
You didn't write that in your report, mention that in your house.
No, I just read the report. No.
Don't you think that would have been helpful in the investigation?
Objection, speculation.
Overruled.
Do I think they would have been helpful to list the gardeners' names?
Yes.
No.
You don't?
No.
So didn't we just kind of get them talking about the fact that they had access to the inside of the house, Mr. Butler?
I didn't make your own. Like I said, I don't recall the conversation I had with Mr. Butler. You mentioned something about gardeners that does ring a bell. Other than that, I don't know whether or not gardeners had access to the inside of the house. I'm just running off memory here. So I don't remember.
Who else had access to the inside of the house?
To the
Don't you know personal knowledge?
Well, that's
Overruled.
to the Butler home.
yes. Who else had access?
To my knowledge, and this is just me speculating here, I would say
Sustained.
It's speculation, Judge.
If you don't know, just say no. I don't know.
All right, time out. Sorry. Can I have parties approach? All right, you may proceed.
You don't know who had access to Clinton Butler's house on or around March of 2021.
I don't know.
You didn't ask him who had access to his house.
I don't know whether I asked him or not.
You weren't interested in trying to find anybody else that may have been responsible for this check.
I had quite a bit of interest in finding out who would be responsible for writing these checks.
But you didn't ask.
I don't remember everything I asked Mr. Butler on the phone.
But in that very short conversation, you did learn that he was a former district attorney.
Yes, yeah.
That's what she said. Fantastic.
I don't remember.
Patricia Butler is also.
Yes,
You didn't talk to her.
no.
Do you know if Clinton or Patricia, who wrote more checks on the account?
I don't recall. Or I know there was something mentioned on who wrote checks. Sorry, who wrote checks. I don't remember which way it went. He said something about one of us writes more checks than the other. I don't remember who.
Would it surprise you that Patricia writes like way more checks than he does?
I don't know the Butlers at all.
You know, in light of that, wouldn't it have been useful to talk to her?
It could have.
Over the course of that 4 hours, eventually an officer, I presume he's an officer, from crime scene investigation showed up, Officer Trevino.
I believe, yeah, he's with the CSI unit. I believe he's a civilian, but yes, someone working for the CSI unit showed up.
And testified earlier that you weren't wearing gloves.
Correct. Yes.
And whenever the CSI unit person Trevino came, he was not happy that you weren't wearing gloves.
He was not.
So that was another mistake, right?
Yes. Very, very human.
Either during the 4 hours that you had, let me back. So you could request that CSI guy. Did you ever request someone that could do handwriting analysis to see who signed the check? Who stole the checks from Clinton Butler?
Objection relevant.
Sustained.
Did you look into that guy? So did you look into the previous check that Mr. Perez said that he attached?
Okay. The check that Mr. Perez said he cashed.
Yeah, he told you that he went
Yes.
into the bank and the day before that he had
Okay.
successfully cashed the check.
I didn't, by look into it, no, I didn't take custody of any other check.
No, I know.
Just that I talked to the bank teller, and she had said that he had come in earlier and cashed another check.
Right. So that's my question. So the day before, Carlos told you that I went in and cashed a similar check day before, and it was successfully cashed.
Yes.
Right? Do you remember that?
Yes. Yes.
Did you? And so that check was successfully cashed. It wasn't held up, and he wasn't arrested.
Correct.
Did you look into that check? Did you go look at it? Did you look at statements? Did you look at anything about
No.
No problem.
past notes?
Officer on cross, you mentioned that you had you were referring to pieces. When you refer to that, what pieces do you need when you're investigating a case or a particular case?
Pieces of evidence or probable cause to build up to the point of an arrest.
Okay. Two offenses, are there elements that meet the statute?
Yeah.
Objection, lack of personal knowledge, calls for legal.
Overruled.
Why did you want to make contact with Mr. Butler?
Two reasons. One is the bank employees themselves said they had made contact with him and that he had provided statements to.
Objection, hearsay.
He's not getting into what was said, so it's not hearsay.
All
He's
right.
saying he's making statements to someone without him saying what was said. That's not hearsay.
All right. If you'll repeat your question.
Why did you want to make contact with Mr. Butler?
You want me to answer?
Yes, you can answer that.
Yes, just because bank employees had spoken with Mr. Butler and made that Mr. Butler had made statements to the bank employees. And so I wanted to corroborate those statements.
Were you able to corroborate those statements?
Yes.
Regarding the conversation of wearing gloves, if Mr. Perez brought the check to the bank, wouldn't his prints have been on the check?
I would assume so.
Okay. During the duration of this call, whose hands did the check pass through, to your knowledge?
To my knowledge, just based off the call details, Mr. Perez's, to bank employees, to my hands, and then to the gloved hands of the CSI.
I pass the witness, Your Honor.
Further questions?
There was eventually a detective assigned to this case,
Yes.
and it was Detective Lola.
Yes. Yes.
Any other questions?
No further questions, Your Honor.
All right. Is this witness excused?
Yes.
All right. You may step down. Other rulers have been invoked, so you're not allowed to discuss your testimony with anyone until the conclusion of the case.
2 threads McFadden left untouched. Pettis told him he'd cashed a similar check from the same source the day before without incident. Nobody stopped him. Nobody arrested him. And when McFadden learned Clinton Butler's wife, Patricia, wrote more checks on that account than Clinton did, he never called her. He also never wrote down the names of the gardeners he'd been told had access to the Butler home. Under the Supreme Court's 1983 decision in Illinois versus Gates, probable cause is judged on the totality of the circumstances, which means the facts that cut against guilt count just as much as the facts that point toward it. A previously cashed check nobody flagged, and 2 unexplored leads to who actually wrote the check aren't footnotes. They're part of the totality McFadden was required to weigh. The charge itself, fraudulent possession of identifying information under Texas Penal Code Section 32.51, requires the state to show Pettis possessed that information with intent to harm or defraud, not just that he showed up holding a check somebody else wrote. Under these circumstances, the state's own witness left the intent element resting on an investigation he admits he didn't finish. This footage ends where McFadden's cross-examination ends, with the officer excused and the jury still weighing a charge of fraudulent possession of identifying information against Carlos Pettis. No verdict is on this record. What 4 hours in handcuffs does resolve is smaller and arguably more important. It shows a stop that started on a vest and a guess and never gathered enough independent evidence to become anything more than that before the state acted on it anyway. This case tested the line the Fourth Amendment draws between a brief investigative stop and a full arrest, and whether an officer's own schedule can be the reason that line gets crossed. A vest doesn't make a case. Neither does 4 hours of waiting for someone else to get to work. If reasonable suspicion can turn into hours of custody just because the right detective clocked in late, whose fault is that really? The suspect's or the system?